Today we have John Ioannou.
Close.
I got it.
Close enough.
I can't get my kids' names right. He's a real estate attorney with over 15 years experience in real estate law. He owns a title company here in Sunny Isles Beach called Florida Closing Escrow, which is dedicated to servicing American and foreign clients throughout the state of Florida, both residential and commercial. As a local title company, where you'll be... Oh, no, sorry.
Yeah, those are questions.
That's questions.
That's it.
It's the first time doing
I
this.
kept the intro short.
All right.
Welcome, everyone. Thank you for being here. I also want to thank the estates for Acqualina for having me speak today. And we're going to have some questions, and we're going to answer some topics. And if you have any questions at the end, please let me know.
Okay. First question. As a local title company, where are you seeing buyers coming from nationally and internationally?
So for our closings since the beginning of the year, we're seeing buyers from definitely the high-tax states. New York, New Jersey, Connecticut, also California. They're starting to buy here in South Florida. Mainly because Florida, as you know, there's no state income tax, number one, and also because Florida has low property taxes. So those are big draws for national buyers. Internationally, we're seeing buyers from Brazil, which just did a closing with a Mexican buyer. Also Colombia and Canada are always big buyers here in South Florida. So what that means to you as realtors, there's an opportunity here for you to follow these trends, keep an eye on these trends, and then target market to these areas.
Once a realtor finds a buyer, how can they ensure a smooth closing?
It all starts with a strong contract. The stronger the contract, the smoother the closing. Fill in everything. Don't leave anything blank. Check off all the boxes. And most importantly, if there's anything agreed to outside of the contract, anything you spoke to the buyer about the seller, about the other realtor, make sure to put it in writing. Text messages and emails are not binding to real estate contracts. And it specifically says it in the contract, and I'll show you on page 10. It talks about it right up here. It says that this contract contains the full and complete understanding. In the last line, no modification to or change to this contract shall be valid or binding upon a buyer and seller unless in writing and executed by the parties intended to be bound by it. So, as I mentioned, text messages, emails, those don't work for real estate contracts. So make sure you put it in writing. And where do you put the additional terms section if there are additional terms? Just in the next page. This is page 11 of the contract. And you put it in the additional terms section. Whatever the agreement is, keep it simple. Just put buyer and seller agree that. And whatever it is, seller is going to contribute $5,000 toward buyer's closing costs. Whatever it is, put it here. Also, if there's any agreement such as the seller is going to stay in the unit after closing, use the pre-printed addendums. You'll see here under U, the post-closing occupancy agreement. It's already done for you, so you don't have to do these addendums. Or a pre-closing occupancy if the buyer needs to be there before the closing. So use these pre-printed forms as much as possible. Put all additional terms in the additional terms section, and then you'll be good to go.
Why is it important to have an attorney involved in the closing process?
Mainly because the contract, it's a legally binding agreement, right? So anytime you have a legally binding agreement, you want an attorney to review it before your client signs it. What I offer or suggest to my realtor clients is to send me the contract first. It just takes me a couple of minutes to look over it because I know what I'm looking for. Send it to me first. We'll make sure everything is done correctly. And then if we start with a strong contract, like we mentioned, then we'll end up with a smooth closing. Another reason is because in case there's an addendum needed, addendums are legally binding agreements that alter or amend the contract, right? So those should also be reviewed or prepared by an attorney, especially if you're using a blank addendum like this. I'm not crazy about this addendum. This you should avoid as much as possible because this can leave you open to practicing law without a license. You're preparing a legally binding agreement. You're technically allowed to do that. So be careful in preparing these. And as I mentioned before, use the pre-printed forms as much as possible. That's going to protect you and your clients. And then what I get a lot of questions are, okay, John, I don't want to bother you. We just want to extend the closing date. I appreciate you not wanting to bother me, but use this addendum. This extension addendum is very good. It can be used for residential, commercial, vacant lands. And basically all you have to do is just check off that first box and then put the date of the extension of the closing date. Put the names at the top, have the buyers and sellers sign it at the bottom, and you're good to go. Also, you'll say, well, I just want to change the buyer's name, and I don't want to bother you with that. Okay, well, there's an addendum for that too. There's an assignment addendum. All of this is pre-printed. All of this is in form simplicity. So use these forms as much as possible to avoid any illegalities that you guys might face.
What are the most important things realtors need to be mindful of to protect themselves and their clients?
If you learn one thing from today, it's timing and contingency deadlines. Timing and these deadlines, if you miss these deadlines, they're deal breakers. You technically put the buyer in default. Once the buyer is in default, what's the seller thinking? Oh, I can get that deposit. So we want to avoid that because that's going to break the deal and kill the deal. Oops, I thought I turned that off. Okay. So it starts from the effective date, right? So everyone knows when the effective date is, right? It's the day the last party signs or initials any changes, right? So that's the effective date. When do we start counting? If the effective date is today, do we start today or do we start counting tomorrow? We start counting tomorrow, correct. So we have today's Wednesday, Thursday, Friday, Saturday, and Sunday. We count the weekends because these are calendar days. Then we go Monday, Tuesday, and let's say it ends on a Wednesday. What time on Wednesday do you have to give notice to a seller? Is it 5 o'clock or at the end of the day? It's actually 11:59 p.m., which is the day of the end of that whatever contingency it is. So be mindful of that. But we get to the 5 o'clock when an extension or a contingency falls on a weekend. So let's say it falls on a Saturday. When do we go to work on the contingency? Is it that Saturday? No, so we go to the next business day, right? What if Monday is a holiday? We go to the next business day, which is Tuesday. What time on that day do we have to deliver notice of any contingency? 5 o'clock, correct. So be mindful of those deadlines, be mindful of the times, and that's going to go a long way for you protecting your client's deposit, because your number one goal is to what? Get the file to closing, but then the second goal is to protect your client's deposit, and so that's the way of doing that.
What are those contract contingencies?
Okay, so for a cash purchase of a home, there's basically one contingency, right? And that's the right to inspect, right to cancel. We've all seen that in the as-is contract. That's paragraph 12. It lays it out here. It's the property inspection right to cancel period. If it's left blank, it's 15 days. I always strongly recommend doing at least 15 days. Don't cut your client short, because even though they don't want to do inspections, you don't necessarily have to do an inspection during this time. This is the buyer's right to cancel. So if they do change their mind for whatever reason, they can cancel during these 15 days. Then also during these 15 days, if there's any issues, if you do an inspection and there's damage or things that need to be changed, this is a good time to negotiate any issues with the seller being able to pay for any repairs. Doing it during this inspection period, you have leverage, because if the seller says no, then you can cancel. After these 15 days, the deposit is non-refundable. So make sure you keep an eye on this contingency period. If it's a mortgage purchase of a home, there's a second contingency, and that's the financing contingency. Right? And we see that on paragraph 8B. And 8B basically says that the buyer has 30 days to get loan approval from the lender. After those 30 days, if you don't notify the seller, if you receive loan approval, that contingency is waived. So you have to be very mindful and speak with the buyer's lender to make sure that loan approval is given during those 30 days. If not, if extra time is needed, then we go back to our addendum that we saw earlier. And then we check off the second box, the financing period box, which basically says more time is needed to get a loan approval. You ask the lender how many more days is needed or in a specific time, and you just check off box number 2, and you put in the time or the date there. This is also applicable for the inspection period. See the third box here. If you need more time in the inspection period, let's say we do the first inspection and the inspection finds a little bit of mold. So you want to then hire a mold inspector, so you're going to need more time for the inspection. So this is the way to extend the inspection period as well. So this is a very good addendum. Make sure to use this. Try not to use the blank form addendum as we talked about earlier. This is at the top here, it's the extension addendum to contract. Inform simplicity, and here, whatever this one is, this is EA2 of the Florida Realtors. See that down there? Okay. And the extension addendum. There are 2 more addendums if the purchase is a condominium. If it's a condominium, obviously we know that condominium approval is required. But for this contingency to be effective, you see the highlighted part, the buyer has to apply with the association within 5 days after the effective date. If the buyer does not, and the buyer waits, this contingency is waived. And if they don't get condo approval and they can't buy the property, then they're going to lose the deposit based on this contingency. So make sure that the buyer applies for condominium approval within 5 days after the effective date. Also in this condo rider, there is a second contingency, and this is also a very important one. This is the delivery of the condo docs. If you're a buyer, make sure you check this one off, 5B. Basically what this says is that after receipt of the condo docs, the buyer has 3 days, excluding Saturday and Sundays, to cancel the contract. And the important thing about this section is this goes all the way up to closing. So let's say the buyer never receives the condo docs. They have the right to cancel all the way up to closing. So if you represent a seller, make sure to deliver the condo docs to the buyer or buyer's realtor, and that's going to start the clock ticking on this contingency. Because you don't want to go to your seller later and explain to them, oh, by the way, they had the right to cancel, they're canceling the contract the day before closing because you didn't deliver the condo docs. So be very careful with that.
But what do you mean by deliver? Deliver, can I send it by email?
You can send it to them, and then there's a form, there's an addendum where it says that the buyer has received the condo docs. Have them sign that to be protected. Worst case scenario, save the email that you sent. It shows proof that they were sent.
It's for seller's agent, right?
Seller's agent is responsible to provide it to the buyer's agent, yes. So make sure to ask your seller for it. If the seller doesn't have it, you have to buy it from the association. Sometimes they're around $100 or so.
Okay. What is the best way to structure and close deals for local and foreign buyers and sellers?
Well, that depends. I have to give a legal answer on that. It depends on what the buyer's plans are for the property. If the buyer's going to rent it, limited liability companies, LLCs, are the best because that protects the buyer from personal liability. If the buyer is a foreigner, multi-member LLCs are best because multi-member LLCs are exempt from FIRPTA. And the good thing about this section is both members can be foreigners. You don't have to have one of the members to be a U.S. citizen. Primary residence, if they're going to take it as a primary residence, best to buy it under your personal name because then you can claim homestead. Homestead exemption in Florida is very important. Be mindful that LLCs and corporations cannot claim homestead. So if you want to claim homestead, it has to be either in a personal name or a trust. Speaking of the trust, if the buyer wants privacy, we've had buyers say, I don't want my name in the public records because obviously warranty deeds are recorded and they're public records. So to protect the buyer's privacy, have them form a land trust or an irrevocable trust or a revocable trust. That will protect the buyer's anonymity.
What do realtors need to know about FIRPTA?
Okay, so FERPTA, a lot of you are nervous about that, but you shouldn't be, because all you really need to know is whether it applies to your situation or not. So FERPTA is the Foreign Investment in Real Property Tax Act, right? And so what this is a tax on a foreign seller. A foreign seller is a person who's not a U.S. citizen or a U.S. resident. So what the government does is they tell the title company that we have to hold a certain amount of a percentage of the sale price at time of closing, and then remit that after the seller's accountant files a tax return with the IRS. So the question first is the seller a foreigner? You have to ask your seller. If they say yes, then the next question actually goes to the buyer. And then the question is, does the buyer have definite plans to use the property as a residence? If the buyer does not, if the answer is no, then FERPTA applies, and you have to recommend your seller to contact a FERPTA accountant and file the proper forms, 82, 88B. And that withholding for the title company for us is 15% of the purchase price. Now this is just a hold. Don't scare your clients too much. It's not the actual tax. The tax is the capital gains in whatever tax bracket that seller is going to be in when the accountant files the return. But at time of closing, it's a hold. This 15% is a hold first. We hold it until the IRS tells us how much to give to them. We give the IRS whatever amount is due to them, and we refund the rest to the seller. That whole process can take around 2 to 4 months. If the buyer does have definite plans to use the property as a residence, then we go to this part of the flow chart, and then we have to look at the sale price. The next question is the sale price. If the sale price is over $1 million, regardless of whether the buyer is taking it as a residence or not, FERPTA still applies, and we have to hold 15% of the sale price at time of closing. If it's between $300,000 and $1 million, then the withholding amount is 10% of the sale price or purchase price. If it's $300,000 or less, then there is no withholding. All right, so this is the layout. If you guys want to, you can always email me. I can send you this flow chart. It's very good. It kind of breaks it down. It's also good to send to your foreign seller.
So under 300,000, the buyer is not really taking any risk, because most of the buyers, they don't want to sign for that. They don't want to risk, because if the seller doesn't pay the taxes, then buyer is responsible, right?
Right, so how do we protect the seller? So then we prepare this addendum. And basically what this addendum states is that the buyer, regarding this property, does swear that they're going to use the property as a primary residence and understands that the property is less than $300,000. And if the buyer does change their mind or anything happens with the buyer, it's now the buyer's responsibility. So this is a very important addendum if you represent a seller, to get the buyer to sign this along with the contract. You sign the bottom, and then you're good to go.
Can foreigners use 1031 exchange?
Foreigners can use 1031 exchanges. Everyone know what a 1031 exchange is? Basically, when you sell a property, instead of receiving that money, you can use that money to purchase something else. And the good thing about the 1031 exchange is there's no tax when you sell. So all of the money that you get can be used to purchase something else. So yes, 1031 can be used with foreigners.
So in that case, would the FERPTA does not apply if it was a 1031? How would I structure that?
You know, it depends on which accountant you speak to. The law is not totally clear on this issue. Some accountants say that because the seller did not realize a gain, there shouldn't be FERPTA. So I've had an accountant say that FERPTA does not apply to 1031 exchanges. However, then you speak to another accountant, they say, well, it's still realized regardless of where it goes to, so FERPTA does apply. I'll have to defer to the accountants. Unfortunately, I don't have an answer, but I've seen both, which is kind of strange.
Yeah, but what is the code saying? Ultimately, they couldn't care about once you pay opinion rather than the rest.
Right.
What the code says. Can be verified, can we get the answer from IRS?
Yeah, actually the IRS, I've
would
spoken
be
to them
ultimate
too.
solution.
It does say that the FERPTA withholding is required.
That's it. So
Because
regardless what one
this
thing
is-
that they have to
yeah.
pay to lose the license.
This is the IRS, so anytime they can tax you, they're gonna tax you.
John, how long is the time frame when 1031, when you sell what you have to buy?
So you have to choose a replacement property within 45 days of the closing, and you have to close within 180 days. All right? Sure.
Yeah, so if it's a multi-member LLC, FIRPTA does not apply or apply?
If the seller is a multi-member LLC, FIRPTA does not apply.
So can they do quick MD to the LLC of multi-member before they want to sell to avoid FIRPTA?
The answer is yes. The addition to the answer is be careful. Don't do it the day before because you're potentially committing a fraud, and that's tax fraud. So if the idea is 6 months, maybe a year, just be careful. I wouldn't recommend that to your clients. I'd stay away from that because you're telling them how to avoid tax. And if they ever do get caught, they'll say, my realtor told me to do it. And then the IRS is going to say, what's your realtor's name? And yes, so always refer tax-related questions to accountants, please.
Any other questions on that? Okay. How can realtors ensure an increased closing success?
Well, I've heard a good idea of pre-qualifying the buyer. That's always a good idea. If it's a cash purchase, try and get proof of funds. If they're getting a loan, get a pre-approval letter because obviously you guys are not tour guides, so you want to pre-qualify your buyers. Putting a successful team together is always a good idea. Find reliable professionals, inspectors, attorneys, title companies, insurance companies, and lenders so you all work as a team together toward closing. Also, tell the buyer and seller that they don't need to be present at closing at the same time or the same day. Just recently, sometimes, and we've all had these clients, you just get a client that for some reason doesn't appear that they want to sell or buy, and they're just waiting for any excuse to cancel. So we stagger those closings. So we do that closing by itself. We keep it real quick. We don't have anyone there with the seller. We do the seller sometimes the day before, or if we need to, we'll do the seller in the morning, the buyer in the afternoon, or vice versa. So be mindful of that. If you do have one of those sellers or buyers, let us know or let the title company know. Don't allow that to blow up at the time of closing. Also, cash buyers can sign anywhere in the world electronically. If it's a cash buyer, we can send them the documents by DocuSign. They can sign it anywhere in the world at any time. Sellers can also sign anywhere in the world, but they have to go to a U.S. embassy because the warranty deed needs to be notarized. If they can't make it to Florida, if they're somewhere in the United States, we can send mobile notaries or mobile closers anywhere in the U.S. One final tip I'd like to tell realtors is to try and attend the closing. I know all of you are busy and you can't make it, but there's two reasons. Number one is you get to pick up your check, right? But then also the other reason is you get a photo op. You post this on your social media, but the other idea is also give this picture to the seller or the buyer or your client, and they're going to post it on their social media. So then they've now given it to all their friends and family, and then maybe one of their friends or family says, oh, actually I'm thinking of selling or buying a home. How was your realtor? Was it good? Do you have their name? And then you just got free advertising there. So once again, thank you all for being here. Thank you to the estates of Acqualina for allowing me to be here. And also, one more special thank you to Cindy Maripol. She's our marketing director.
Does anybody else have any more questions for John? There you go.
Now, what contract do we use for pre-construction? You have to use the
Developer
developer's
contract.
contract, okay.
Yes, absolutely. You have to. And I'm sure, Michael, you have
We have a
those
few of
contracts,
those.
contract ready. Yes, ma'am.
So if you have a cash
buyer, does anybody have to do any due diligence to make sure the funds are legal?
No. You can ask for proof of funds if you want to, but we just basically at the time of closing, we'll finalize the HUD. We'll prepare it, we'll send that out a couple of days, and then they have to wire it to us. No cashier's checks or checks at time of closing. They'll wire it to us, and then we have the closing. So that's how that goes. Okay, thanks again. Enjoy the rest of the brunch. And if you have any clients for Acqualina, bring them by, right?